My name is Emily Lamb, and I will be presenting the cases to the board for their review in today's public hearing. Members of the public at this time, please take a minute to turn off or otherwise silence your cell phones or other devices so that the board can consider cases without interruption. For these public hearings, the board reviews the correspondence submitted in support of and opposition to these cases. The board also reviews correspondence and recommendations from other government agencies in preparation for the hearings. In today's hearings, staff will present the site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, the board will hear those wishing to speak in support of the appeal. If the appeal has opposition, the board will then hear from those parties. After the opposition presents its testimony, the appellant will have a period for rebuttal. According to the BZA rules, the appellant has 5 minutes for presentation if no opposition is present. In contested cases, the BZA rules allow 10 minutes for each side to present testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some portion of the allotted 10 minutes. At the conclusion of each hearing, the board will deliberate and then vote on that case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, Section 1740-180. All section numbers that we refer to come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The Zoning Code was adopted by the Metro Council and became effective on January 1st, 1998. I will introduce the entire Zoning Code and make it a part of today's record. The Metro Code requires a record of these proceedings. Because BZA meetings are recorded for the Metro Nashville network, it's imperative that anyone addressing the board please come forward to the front table, speak into the mic, and be sure to identify yourself by name and address, and then make the desired presentation. The Metro Code requires 4 members of our 7-member board to establish a quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more board members are present, but the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to Chancery or Circuit Court within 60 days of the entry of an order. Additionally, as per the BZA rules, an aggrieved party may file a motion for rehearing by the BZA within 60 days of the original hearing date. After that time elapses, the board's decision becomes final and no further action can be taken. If your appeal is granted, you're required to obtain the permit for which you applied. A permit must be obtained within 2 years for a board approval to remain valid. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all cases have been filed in proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. I do have some preliminary announcements regarding deferrals and withdrawals. First, case 2019-300 has been deferred to November 7th. Case 2019-350 has been deferred to October 3rd. Case 2019-376 has been deferred to October 17th. Case 2019-388 has been deferred to October 3rd. Case 2019-398 has been deferred to October 3rd. Case 2019-401 has been deferred to November 7th. Case 2019-403 has been deferred to October 3rd. Case 2019-404 has been deferred to October 17th. Case 2019-415 has been deferred to October 17th. Case 2019-416 has been withdrawn. And that's it. For members of the public, our board utilizes a consent agenda at each of its meetings. One board member reviews the record for each case prior to the hearing and identifies those cases which meet the criteria for the requested action by the appellant. If the reviewing board member determines that testimony in the case would not alter the material facts in any substantial way, then the case is recommended to the board for approval. We'll enter into the record those cases that have been so recommended, and if anyone is here in opposition to the cases identified for the consent agenda, please raise your hand, make sure I see you so we can remove it from the consent agenda and hear it in its regular order. Please note that on any sidewalk case that is placed on the consent agenda, the applicant has agreed to the recommendation made by the planning department. Mr. Chairman, these are the cases that have been recommended for the consent agenda. First case, 2019-315, involving property at 3041 Dickerson Pike. Is there anyone here in opposition to case 315? Next case, 2019-317, involving property at 6211 Laramie Avenue. For the board's edification, the sidewalk variance on this particular request was granted at the last hearing. The applicant has agreed on the setback request, which is before you today. The applicant has agreed to the condition that the side street setback will be 20 feet. Is there anyone here in opposition to case 317? Seeing none, the next case is case 2019-378, involving property at 804 Onslow Way. Is there anyone here in opposition to case 378? Seeing none, the next case is 2019-384, involving property at 924 McFerrin Avenue. Piece of information for the board: the applicant has withdrawn the parking variance request, so the only issue is the landscape buffer and sidewalk variance request. And as always with the sidewalk cases on the consent agenda, the applicant has agreed to planning's recommendation. Is there anyone here in opposition to case 384? Next case, 2019-397, involving property at 4201 Central Pike. Is there anyone here in opposition to case 397? Next case, 2019-399, involving property at 1816 Owen Street and 1817 10th Avenue North. Is there anyone here in opposition to case 399? Yes, so we'll take that one off the consent agenda and hear it in its regular order. Next case, 2019-500, involving property at 3313 Colby Drive. Is there anyone here in opposition to case 500?
400. Yeah.
Okay, I'm sorry. 2019-400, 3313 Colby Drive. So are you here in opposition to that case? You are. Okay, so we'll pull that one and hear that one in its regular order. Case 2019-405, involving property at 1104 Paris Avenue. For the board's edification, the applicant has agreed to the condition that the second structure will be limited to a DADU, a detached accessory dwelling unit, and will meet all the other DADU requirements. Is there anyone here in opposition to case 405? Next case, 2019-408, involving property at 1610 Gray Bar Lane. Is there anyone here in opposition to case 408? Yes, we'll pull that one off and hear it in its regular order. Next case, 2019-409, involving property at 5915 Robertson Avenue. Is there anyone here in opposition to case 409? Seeing none, next 2019-410, involving property at 709 Wilson Wood Place. Is there anyone here in opposition to case 410? Next case, 2019-413, involving property at 825 Elm Hill Pike. Is there anyone here in opposition to case 413? Next case, 2019-414, involving property at 6400 Charlotte Pike. Is there anyone here in opposition to case 414? Seeing none, next case, 2019-417, involving property at 905 and 907 54th Avenue North. Is there anyone here in opposition to case 417? Next case, 2019-418, involving property at 151C Rains Avenue. Is there anyone here in opposition to case 418? And finally, case 2019-419, involving property at 149 Rains Avenue. Is there anyone here in opposition to case 419? Seeing none, to review, Mr. Chairman, the cases on consent agenda are 2019-315, 2019-317, 2019-378, 2019-384, 2019-397, 2019-405, 2019-409, 2019-410, 2019-413, 2019-414, 2019-417, 2019-418, and 2019-419. Are y'all here in opposition to one of those? This is just the consent agenda. These are not all the cases on the docket.
Ma'am, I made a mistake on case 400. I'm supportive of that.
Okay, so is there anyone here in opposition to case 400 at property 3313 Colby Drive? Seeing none, that one would go back on the consent agenda. So that's 2019-400.
Yes, ma'am. I went to Midtown, and this is again 3214 Charlotte, 376.
I don't believe that's on the consent agenda. It hasn't been called yet. Oh, that one was deferred. I'll get with you at the break. So, Mr. Chairman,
All
staff
right,
and
we have
solicitor.
a motion for the consent agenda. The overwhelming majority are sidewalk cases that agree with planning, and hopefully we won't have those as the new law goes into effect. Those will be worked out administratively in the way that we have worked those out with planning in this committee. It sounds like a long consent agenda, but most of those are sidewalk cases. So we do have a motion to approve that. Do we have a second?
Second.
We have a motion, have a second. Any discussion? All in favor of the consent agenda, say aye. Any opposed? The consent agenda passes.
Members of the public, if your case was just approved on the consent agenda, you are welcome to stick around for the meeting, but you're free to go at this point. Please give our staff until Monday to process all the documentation associated with your appeal, at which point you can come in to pursue the permit that you applied for. Mr. Chairman, before we move on to cases to be heard, we'd like to take this opportunity to recognize any elected officials who are in attendance. I saw Council Lady Johnson. Would you like to address the board?
She can contact me by email, and I can let her know.
Good afternoon. I'm Councilmember Mina Johnson. I do appreciate giving me my privilege to speak at this time. This will be my last appearance in front of you as a district council member, and I do really appreciate the opportunity. Because since you do have lots of agendas, so I will try to be brief. However, I am speaking on the case of short-term rental, case number 2019-361. This is rather unusual and complicated cases, so I would appreciate if you would bear with me and give me a little bit time to go through to make a point. And if you have any question during my speech, please feel free to stop me and ask any question.
And Council Lady, this one is one that we did hear at the last, at our last meeting. We did hear this case, and it's held up in votes at this point. And so I think a lot of people are familiar with the case of the trust, and we have heard the case. So just so you have that perspective, that it won't be heard fresh today, but we definitely have heard the case, but appreciate what you have to say about it.
Yes, I have watched, because I was unable to attend in person, so I myself watched a couple of times your deliberation and your opinion and so forth. So that's why I just wanted to present the decision. So if you are familiar and everybody watched, so why don't I get to the point? Because the reason this permit was rather revoked or denied is based on one specific language, which is Tennessee State Code annotated 13.6, what's the number? 13.607. Wait a minute, let me get to that. So 13.7-603. So the specific one, it says, the zoning administrator denied, not based on the metro zoning, because the law, dictate short-term rental permit is revoked or denied or approved is based on BL 2017-608. That's the existing law. So in that existing law, there's no reference on transfer of ownership or sold or change of ownership of the property. Instead, zoning administrator went outside of metro zoning, then went to Tennessee State regulation. So in that section, it says the ordinance, resolution, regulation, rule, or other requirement in effect at time of the property began being used as a short-term rental unit is the law that governs the use of the property as a short-term rental unit. So that is BL 2017-608. until the property is sold, transferred, ceases being used as a short-term rental unit for a period of 30 continuous months, or has been in violation of a generally applicable local law 3 more or separate time as provided. So we can agree, the applicant did not have any violation 3 consecutive times during the 12 years. And the applicant did not cease the short-term rental operation. They did so when they received the letter. So the only question remains is, so the property has not sold. It has no buyer, no seller. What happened was simply transfer of the title or title change. So it was said at the meeting because the title, or rather, I guess title, was changed from individual name to revocable trust. So therefore, the zoning administrator's point is the short-term rental permit holder or applicant must change to revocable trust. So that was not, as a council member, when we passed the short-term rental, that is not our intent. Our intent is always permit holder need to be natural person. We don't want LLC or corporation, those entities to hold up a permit. Instead, we want to make sure short-term rental regulation was properly followed. So the short-term rental permit holder must be natural person. That is our intent. I just want to make it clear at that point. So one thing it was not clearly stated was the property based on the bad recommendation by estate lawyer. Unfortunately, the estate lawyer name is Mr. Hazard. Mr. Hazard recommended the property to be transferred from individual, Mr. Levine, to revocable trust. And the applicant was advised by changing the title from individual to revocable trust, they will not lose short-term rental permit, none whatsoever. That was a recommendation. So they, I believe you have a document, affidavit coming from Mr. Hazard. It was indeed his mistake, and it was not his intent. If he had known that change of the trust will cause to lose their short-term permit, he would never have recommended. So that was, I just want to make sure it was on the record. It was not spoken at the last meeting. So under these unusual circumstances, the applicant is not asking to change the ownership of the permit. Rather, they're asking continuous use of existing short-term rental permit. And applicant is not asking to change the status. Applicant is not change the law. Rather, they would like to obey precisely. That's what they have been doing. So by doing so, applicant, the day after the hearing, they went and changed back the property, the title from revocable trust to individual. So one thing I would like to make aware is there was such case in this short-term rental permit. There was several cases, some applicant used to be an individual permit holder, then changed their property to living trust. And then somehow it was discovered by zoning administrator, the applicant changed back to individual. Then their short-term rental permit was issued without any problem. So my constituent is not the first case to have that kind of what they call forgiveness. So I would like you to not, just to see the intent of Tennessee Short-Term Rental Unit Act. The intent of Tennessee Short-Term Rental Unit Act is allow, rather give us to prohibit, for us to prohibit the short-term rental. That is the intent, not for us to seize the short-term rental business. So by doing so, it's confusing because it says until the property is sold or transferred. So the word transfer is the kind of hung-up word. So it seems like in this case, zoning administrator, in good intent, try to protect or precisely follow the intent of state of Tennessee law as well as metro zoning law. Instead, kind of my constituent becomes a gotcha because your property was transferred, therefore your permit is no longer valid. So that was the case. But in reality, it was rather really unusual, bad circumstances, so they are victim of the condition. So considering there was the case in the past, such property owner change from individual to trust and then change back to individual, then their permit was issued without any delay or problem. So I would like you to find my constituent's case is the same. Considering unusual circumstances, now their title was changed back to individual, which is in line with the short-term permit holder. So I do be happy to answer any question if you have.
Thank you. Is there any questions for Council Lady Johnson? No, I appreciate you being here.
I don't have a question, but thank you for your service the past 4 years.
Thank
appreciate
you.
it.
Appreciate it.
And we saw you as a neighborhood activist many times before you were elected, and you've been active since you were elected, and I'm sure we will see you many times
Yes.
in the future. So
Yes,
appreciate
neighborhood
it.
is in my heart, so it will not change, and I do thank you for your
Appreciate
courtesy
that.
to allow me to speak at this time.
Sure, thank you.
I don't see any other council members, so unless I'm missing something, I believe we're ready to start with the first case.
Okay, I have the first case, and that is a case that has been on our docket for quite a while, and I and Christina will be recusing ourselves from that case, and I'm going to turn the gavel over to my co-chair.
Okay, so this case has been on the docket for almost a year or over a year. I think we ought to consider reopening the case to be heard again, so I will make a motion to that effect that we reopen the case.
It was deferred October 17th.
All in favor? Aye. Okay, all opposed. Okay, so the applicant will have 10 minutes total to make their presentation, and then the opposition will have 10 minutes total to make their presentation.
And to give a brief reminder to the board before the appellant steps to speak, this is a property on 1506 Church Street. The zoning map here shows you the zoning is MUIA. This is the aerial photography giving you a sense of the surrounding area. Site plan submitted by the applicant. And these are the photographs showing you the current conditions of the property. Mr. Pepper, as you pointed out, this case has previously been on the board's docket. It's a parking variance request, and I'll let the appellant refresh you on what his request is. It was deferred several months ago in order for him to bring you some new information, so we'll also have an opportunity to provide that information to you, and he can answer any specific questions about the application, and if you have questions about the code, I'm here to help you with that.
Thank you. So we're ready for the appellant.
Good afternoon. Testing. Okay. Good afternoon, everyone. You would think I would know that since I've been here a few times. But first of all, I want to thank you all for your service and the time that you all are contributing to help make decisions in our city as the city rapidly grows. And we understand that there's no shortage of hearings as we hear the docket. So I'm going to use my time.
Mr. Mollett, can you introduce yourself too and give your address for the record, please?
Sure.
Yep.
And so my name is Lee Mollett. I am a real estate developer The address of the property that we're working on that we're here about is 1506 Church Street, Nashville, Tennessee 37203. It's right 2 blocks off of the interstate. So if you think NES, but going back towards St. Thomas Hospital, we're 2 blocks west of the interstate. And so I recognize there are a few new faces on the board. So I do want to give, especially since we're reopening, I want to give a brief history of where we are, or where we were, and kind of where we are now. This particular project is a 52-unit condominium development. It allows for short-term rental in it. Currently, we've sold 47 of the 52 units in pre-sales. The overwhelming majority of those units have been sold to investors who will use them as short-term rental. We have a property manager, Playlist Properties, that will actually manage the short-term rental aspect of the property. We also have a parking manager or parking managers that we're interviewing now, and will source the parking management in the near future. A few of the units have also been sold to folks that will actually live there, and you wouldn't be surprised that those units have been sold to folks that will be working at Amazon. And those folks don't have cars currently. They live in Seattle, and they don't expect to buy cars. And the reason this building is appealing to them is that it's 2 blocks from work, so they can walk back and forth to work, and it's very convenient. Our last, I guess this time last year, when we first started when we first had our first hearing, kind of at the end, one of the members who's not here today, Ms. Chappell, I think, or Chappelle, kind of ended with, yeah, there's probably some sort of reduction needed, but really didn't really come to a conclusion as to what that reduction should be. And then after our last meeting earlier this year, the board asked me to bring back a proof or evidence from a similar property or property manager that manages these types of properties to get their opinion on what was needed. And so you have in your packet from Mint House the letter. Mint House manages quite a few properties in the area, and specifically, if you think the Master Passport building, that's a building that they're taking over as well. But in that letter, it shows that on average, they recommend that for every bedroom, we have 0.4 of parking. And then also, they noted that of the folks that stay in their properties, somewhere around 50% of those folks actually bring a car. So, and then also I noticed, I read through the responses from the opposition that also gave you some statistics. What I'll ask you to note, though, is that those are not apples to apples. When you think in terms of 1818 Church Street, that's an apartment building. It's not a short-term rental building. They do have short-term rental in the building, but it's totally an apartment building. It was built for apartments. The Chelsea, another building that was noted, is in South Nashville, and so it's not an apples to apples. And it was an apartment. It was an apartment building as well when it was built by Main Street, and pretty much all of the properties that were referenced, none of those are apples to apples. The majority of them, one, are further out than our property, and then two, they're not short-term rental. They may have some short-term rental components, but they're not apples to apples with our property. So I will ask you to note that. Now, I think the other thing that I want to bring up is so we're asking to have a reduction of units from 40 units, and I think our initial request was 11. units or parking spaces. We've been asked several times and talked to our council member, and the question was, what's a proper number? And I would submit to you, based on the evidence that we have, then from Mint House and even from some of the other property managers that you have, that somewhere 16 to 20 is actually what they see as the number. If we use 0.4 for Mint House, and that maybe puts us at 16. If you just said, okay, and the thing that we have to keep in mind is that the building's not always 100% occupied. So when they say, half of the people that come actually have cars, it's not that we're have all 52 units occupied. Now, we want to. We want to be, 24/7, 52 units full, but that's really not the case. And so if we if we use their number, then, that's 20 parking spaces. And as I told Councilman O'Connell, who actually wrote a letter and supports a reduction, we'd be amenable to somewhere in that range also. Also, you'll see that the Graduate Hotel, which is a couple blocks down the street from us, this board granted them a similar variance in the past. I note that in one of the responses from the opposition that their particular building is not too far from the downtown code. Well, they're probably 6 blocks further from the downtown code than we are. We're right across the street from downtown code. So DTC, if DTC, we wouldn't even have this conversation because it doesn't require any parking. And so we are very close to downtown. Kind of last thing I'll say with my time right now, because I do want to have time to come back, is that, when we think in terms of the opportunities now, so many people use Uber and Lyft and different types of ride share. And so that is really what's driven the reduction in the need of parking spaces. Our opposition will talk about places like McMillan Court, which is down the street from us. I've yet to see that parking space full, and you have pictures of their parking lot. Even during the NFL draft, which arguably is, or inarguably is maybe the busiest time the city has ever had, it wasn't full. Now, the building was full, but the parking lot wasn't full. And so I would submit to you that it's just a change of time. And as things change, as Kmart goes out of business, Amazon comes in business. And, some businesses, because they aren't willing to make the change or don't make the changes, they kind of die out. And so that's where I want to leave it for now, and then I'm happy to come back and answer additional questions. Thank you.
I have a question now for you. How many total bedrooms? I'm looking at the letter from Mint House. How many total bedrooms does the property have? And it may be in our materials somewhere, but
total is there are 54. So 54. Majority of those units are 1 bedroom.
Okay, so 54.
And then we have two bedrooms.
Is the 54, the 0.4 parking spaces times 54 gets you 14 parking spaces is enough to meet that requirement? Okay.
Right.
Okay, you'll have a minute and 45 seconds for rebuttal.
Okay, thank you.
Okay, we'll hear from the opposition.
And as a reminder to the opposition, Mr. Dean, of course, knows this, but there's a cumulative 10 minutes for everyone in opposition, so you're sharing this 10 minutes.
Emily, you think you can find that? If it would please the board, my name's George Dean. I'm an attorney here in town, and I'm here representing Linda Shapani, I'm sorry, and several of the neighbors who have businesses along the street. I don't know whether you can see it on your monitors. I put this together, as I understand it, and this is from kind of the numbers from last year. What I really wanted to point out was that the code allows a decrease in the number of parking spaces automatically for a property like this. So if you look on in the upper left of that diagram, that paper up there, it says use, and immediately below use it says 51 bedroom apartments. Shift over one column, says required, you need 1 space per apartment for a total of 50. If you come back over to uses, there's 2 two-bedroom apartments which require 1.5 spaces per apartment. That would be 3. There's also 2,000 square feet of retail space. There are no parking spaces required for up to 2,000 square feet of retail, so none for that square footage. So the total actually required on the site is 53 parking spaces, rather than the 40 that we've been talking about. How do we get down to 40? Well, you're allowed to decrease it by 25%. The adjustment is built into the code itself, anticipating that people will use Uber and Lyft and come by other means and not have their own car. As a result, the code has already taken into account those things passed by the Metro Council and reduced it from a total of 53 spaces that are required down to 40. The applicant here wants to further reduce that by another 26 spaces. And the reason I wanted to talk to the board, and if we could move down to the next part, thanks. Well, I'm afraid I won't be able to read that too easily, but my main point is that this is not a decision really for the zoning board. In order to get a variance, you have to show item A up there. This is from the Metro Code, but also the state statute that governs variances in Tennessee basically says that you've got to have some exceptional physical feature of the property to justify granting a variance for anything. There's no exceptional physical feature of this property. It's basically a rectangle. It is similar to the other properties in the general vicinity. Actually, it's a little larger than most of those. Sometimes you have people argue about, I've got a smaller site size. That, too, is not really an exceptional physical feature. There is no exceptional physical feature. That's why something like this should go to the Metropolitan Council, and if the council wants to change the parking so that it reduces it for everybody across the board, then that's appropriate. But rather than the zoning board granting a special relief to just one person, that's not what a variance is created for. Item B says, is the property exceptional from the other properties, different from the other properties in the vicinity? It's not. It's basically they're all the same out there. Is the hardship self-imposed? Well, yeah, because basically we're building too much space that we can rent and not enough space in order to do the parking. Financial returns, are they the only real reason for the hardship? And again, I don't have any problem with the applicant making as much money as he possibly can. The American way, and no problem with that. And I should say, we don't have problems with the development. If the parking can be provided as required, that's great. We're all in favor of it. But the way it's designed and laid out now, that's not the case. And the reason is financially motivated. It's not because there's an exceptional physical feature of the property. It's because you can make more money by putting up more units to rent than you can with the parking spaces. I understand that, and I don't have any problem with it so long, again, as you meet the requirements for the parking spaces. Does the granting of the variance have any impact on the surrounding neighbors? And it does. My client has a business there too. She complies with the zoning and the parking space regulations. She provides parking to employees, and she has tenants for whom she provides parking. But it's very difficult now, without this new building with insufficient parking. People come and park in her employees' spaces, take her tenants' spaces, so that they can't find a place to park. As it is now, this building will only exacerbate that situation further. And finally, will the variance impair the requirements of the zoning ordinance? Yeah, the zoning ordinance requires 40 parking spaces at this location. The application doesn't meet it. There's no exceptional physical feature of the property to justify a variance. Mr. Pepper and I actually engaged, I don't know whether you recall, but when it was first here maybe about a year ago, one of the things I suggested was the way I get around these problems when I represent a developer is I find another piece of property, because the code allows you to do this off-site, and I get that property and use the other property as some of my parking. That's not been done, even though this developer, as I understand it, owns the property across the street. He could provide additional parking. He just has chosen not to do that, and instead is asking the board for a variance that doesn't comply with the requirements for a variance. And I think some of the folks may want to say something additional.
Hello, I'm Linda Shapani at 1500 Church Street, right next door to, I own the building next door to this project. You have in your packet, you have 23 signatures from surrounding business owners and property owners in opposition to this variance. We believe that the variance would be injurious to our business and to our property. The streets are already congested. We already have problems with parking. At this point in time, actually, Lee and our Councilman Freddie O'Connell, the city of Nashville, have been sued by Deja Vu over parking, and so we're well aware of issues with parking, and that suit continues. We have a new 4-unit building that's coming up. I have a block from this project, and he is building it to code, so you will not be seeing him. He recognizes the need to have parking. And we were asked at the last meeting to provide, as Mr. Millett had said, that looking at parking in the surrounding areas. Well, I would disagree with, McMillan Court is right down the street from this project. There are 15 units and there's 26 parking spots available, and there's also some overflow if they need that. The 1865 building, that project is strictly short-term rentals. They are providing 1.5 parking spaces per bedroom, and they're hoping to get it up to 2 because they feel like that Nashville is very centrally located and that people are driving to Nashville. They do say that once they get here, they use shared rides to go downtown and do entertainment, but they are bringing their cars. So those two particular are short-term rentals. I would also remind you that the Graduate Hotel, actually their variance was for 57% of the required parking, so it wasn't as steep as what this appellant is asking for. I also spoke with Stay Local and Turnkey, which are also short-term rental property managers. They told me that, again, that Nashville is very centrally located and that providing parking was a selling point for them. The Met House, the short-term rental people, they also said in their letter that 5 to 6 of 10 visitors bring a car to Nashville. So that's 50 to 60% of guests. So individual guests bring a car to Nashville. So just as a reminder, short-term rentals allows 2 persons per 1 bedroom plus 4. So there could actually be 6 people in a 1-bedroom short-term rental. 2-bedroom units, of course, they allow more. There is 2 per.
Ms. Shapani, you've got 1 minute. I see
Sorry.
you have somebody next to you.
Yes, I do. So anyway,
a
a total of that could be 316 people at one point in time. So.
Okay, thank you.
Hi, my name is Ann Braun. I own and operate ESS located at 203 McMillan Street. I also have a parking lot at 206 McMillan Street. Let me tell you, the parking situation is super tight. I leave the office late in the evenings. I drive by McMillan Court. I often see their lot full. Also, I'd like to make the point that the appellant is relying heavily on alternative forms of transportation and yet has made really no provision to support these. The Graduate Hotel, I'm sure, has a place for Ubers and Lyfts and cabs to pull over to discharge passengers. There is no such accommodation here other than for them to enter a very tight parking garage off of an alley. So the choice is to block the public alley or to block the street. Church Street is very congested there. And then McMillan, if people are turning off onto McMillan, they stop, then someone else coming off of Church could have an accident and hit them and cause accidents and cause injuries to real people. My own office manager was involved in an accident like that. Her spinal cord was almost severed. So real people could be really hurt by this bad planning. Thank you.
Okay, thank you all.
Thank you.
So, Mr. Millett, you have some time left for rebuttal, I think a minute or 2. We're resetting the clock for you.
Okay, thank you. So it's not lost on me that we have opposition. One of the things I will say is that when this ordinance that Attorney Dean referenced was actually went into effect, Uber and Lyft were not even on anybody's brain. And so to insinuate that it was developed with Uber and Lyft in mind is not, I wouldn't say that it's accurate. Second, the Graduate Hotel, the reason that they asked for more, they only asked for 50% is they actually have meeting spaces and they have banquet spaces, so they will need more spaces. We don't have meeting spaces. We don't have any banquet spaces, and so that we don't need the same, we can operate with less. The other thing is when you take a look at the list of people that have opposed, in one instance, probably 4 of those people operate out of the same building that Ms. Shapani owns. Her son, there's a doctor that's in there, and her operations person. And so while there will be an inconvenience to them because they use our parking lots right now, and we swap some parking spaces, but they're on the plus side of the number of spaces that we use. It's not accurate to think that all of those people are more than one person, if you will, or more than one entity. And then, and the last thing I'll say is that their references to other entities is not apples to apples. It just isn't. It's not the same proximity into downtown, not the same type of properties. Our hardship is the same hardship that the Graduate noted, and we'd have excessive parking spaces, and it's not. We're trying to promote a more pedestrian-friendly environment, and so by doing this, we are able to do that. And as Attorney Dean stated, we own all the parking next door, and it'll be a private lot that we own, and our guests will be able to use that.
You're out of time now.
All right, thank you.
Sure.
All right,
Do we have any questions? I have one, which is, and Mr. Dean, jog my memory, you do have you own the parking lot next door, correct?
Yes.
And so why not make it available as off-site parking?
It is. It is, and I've always said, just as a matter of time today, I didn't go into it again, but we own the parking lot next door. It will be accessible to guests. There's going to be 2 buildings, and it's accessible to guests in both buildings. That second building will not utilize, and it'll be a short-term rental building as well, 77 units. We won't utilize all the parking spaces in there, but much like hotels downtown or what have you, it's a paid parking lot. So our guests, when they come to town, they'll have, if they're bringing a car, then they'll pay to park in that additional parking lot.
Okay. And I think the zoning administrator can probably remind us on this, but I think that what Mr. Dean is referring to is it's something more than just saying these will be available if people want to park. I think there's requirements that you have to contractually commit to making those parking spaces available for a certain period of time, as I recall. And why I hear you saying it's going to be available, but why not go the extra step required by the code and contractually commit to making those parking spaces available?
Yeah, excuse me. So that's not an issue. It's just, again, it's just like any other scenario. If there's not on-site parking, then you pay to park next door. We'll have, we're open to, if that's subject to, if you all say, hey, we'll give you an X reduction, but we still want you to have a contract with the your parking lot to have. In addition to, we park in this building, we park 14. If you all say, hey, if you all agreed to reduce to 20, and we need to have a contract to, or lease to carry the other 6 parking spaces, we'll do that. That's not a problem for us, and we're definitely willing to do that.
Okay, I appreciate that, but that's not typically what we do. Is we don't tell appellants, here's what will get you your variance if you'll do this.
Okay, so we will do a lease to essentially accommodate the space. And so at this point, because we hadn't finalized this aspect of it, we don't know what that number is. So if it's whatever that amount is, we will make accommodations. We're going to have to do that anyway for codes, because based on what you all require us to have, that's going to be, essentially that's the law, that's the rule, and we'll have to follow that.
Thank you for that, answering that question. Any other board members have a question? Okay. Okay, we'll end the public hearing at this point and begin discussion. Thank you, Mr.
Okay.
Black.
All right, thank you all.
Okay, thoughts? Okay. Any discussion?
I guess the only, I think this one is a difficult one because while I do realize that it's likely that Lyft and Uber have had an impact on how people use cars and how they travel, I think both sides presented evidence to sort of contradict both points. And so I think the presentation on like the standard for a variance and whether that applies to this case, like I'm wondering if some of this was a self-imposed hardship. So I think I have a hard time getting to a reduction when I'm not clear on what the hardship is at this point. So that's.
Well, I agree with you. Is that a motion?
Yes, I'll make that a motion.
And I'll be more than willing to second that motion.
So I guess the motion would be that in this case, I move to deny the variance request and that the zoning administrator did not err because a hardship that's unique to this particular property has not been demonstrated, and therefore a variance isn't warranted.
Okay, is there a second?
And there is a second.
Okay, so we have a motion on the floor. All in favor, say aye. Aye. All opposed, no. So that variance is not granted.
I'm going to go get the board members who
Right.
recuse themselves. Be right back.
So now you get to show the hammer back over the hammer.
I didn't even get to use the hammer.
You got 67 minutes.
Well,
Yeah, I'm
yeah.
watching.
Okay,
Really,
Yeah,
don't
it's-
want the marshal showing up.
that's right. He can deal with the sheriff, or the state court officers, but.
So before we move on to the next case, case 2019-393, this is involving property at 4422 Scenic Drive. The councilperson wanted to come speak to the board about this and got tied up in a meeting, so he has requested a deferral on this case. I've spoken with the appellant. He's agreeable to the deferral so that he can work with the neighbors and see if they can work out some of the opposition. So it may be appropriate for the board to take a vote on deferring case 2019-393 to October 3rd.
Make a motion.
We have a motion. Is there a second?
Second.
Motion and a second. Any discussion? All in favor, say aye. That motion, that case 393 is deferred.
Is that until October 3rd?
Yeah, till
To October 3rd. So if you're here on case 393, that's deferred to October 3rd.
Excuse me, could you read the reason why again, please? We didn't quite-
Because the councilperson and appellant both requested it. I'll talk to you at the break. Next case for the board to consider is case 2019-351. This is involving property at 1306 Gallatin Pike. Is the appellant here? Yes. This is property at 1306 Gallatin Pike. This is an item A appeal challenging the denial of a permit for an automobile repair and used automobile sales facility. Zoning map here shows you the zoning of the property is CS. Aerial photography giving you a sense of the surrounding area. Site plan submitted by the applicant. And finally, the photographs showing you the current conditions of the property. Before the appellant speaks, I will give the board the brief background, since this is an item A appeal challenging our denial of the permit. This was an application for a permit for an automobile repair and used automobile sales facility. It was denied due to distance requirements. The current law requires 1,320 feet between dealerships and used and repair facilities. you'll see a letter in your packet from a zoning examiner back in August of 2017 stating that this use was allowed at this property. I would point out that in August of 2017, the use was allowed at the property. The applicant purchased the property in March of 2018. In October of 2018, before he had filed for an application. So about 6 months after he purchased the property, the law changed to require 1,320 feet between these facilities. He filed for the permit in July of 2019, which was about 8 months after the law changed. So although the permit was valid, although the property was eligible for this use at the time he purchased it, he failed to apply for the permit, therefore there was no vesting. And so no permit was issued. So when he applied, it was denied based on the current law.
So if he had applied when he bought the property, it wouldn't be a problem because it was...
If he had obtained the building permit, if he had applied and obtained the permit, yes.
Okay.
But because he didn't do that before the law changed, the law in effect, when he comes in to apply, is the law that governs. Is there anyone here in opposition to case 351? Seeing none, the appellant will have 5 minutes to make your presentation. Please be sure to identify yourself by name and address.
Yes, sir. If you state your name and your address, and then in an item A appeal, if you could tell us, what happened, but specifically why the zoning administrator is incorrect, why the zoning administrator erred in this case.
Yeah. My name is Mushtaba Rabi'i, and I appreciate for all that you give me this opportunity to come here to talk to you. As anytime I buy a property, any place, I go to zoning and find out what's the zoning of that property. And I did exactly regarding this matter. And that time I bought it and I purchased this place on January 2018. But as all of you know, these days it's really hard to do everything right away. And it took time for the plan and this stuff. And by the time I got the planning ready, floor plan ready, it took time. And by the time I came, it was around, as she mentioned, it was around July I came, but before that I came to the zoning and I said, oh, we cannot have it anymore. I said, I have a grandfather letter that from the issue from the zoning. And when the zoning issue is a letter, it means it's an official letter. And everybody can consider that letter as an official letter. Anyhow, let me give you a brief history of this property. I don't know, maybe some of you know this property is Lycra. It looks like that. It's a piece of property, land. Is all the people, alcoholic people, druggish people, laying down over there. And on 104 McKinley, which is, you see that picture, that house belongs to me. The first house on the right-hand side. 3 times I have it broken. One time they came, because I renovated this house. One time they came and got all the vanity from the bathrooms. The second time, they broke the windows. I have the picture. The third time, they took all the screen from the backside. And I have the 3-time police reports regarding that matter. That place is in a very bad situation on Gallatin Road. And we need to change this situation. The plan I have is going to be like that. I'm going to have a car lot, no oil, no grease, no shop, no nothing. And it's going to be a very neat place, as I have one right now at the 604 North Carrollton Pike. Exactly the same as this one. I don't have any issue with that. But the reason we need to change this place as soon as possible, and I talked to my commissioner, Mr. Zach Young, and he's agreed with me too. And he said he's agreed to change it to the car lot. I read the law that why they changed the law. But in my experience, because I've been in this business, and you know maybe better than me, when the one street has one type of marketing, like a car lot, like an electric shop, all one together in one street is good for the consumer and also for the sales. For it's going to be market. I don't know why they said no. This is it has to be. I guess the regarding of the dirty job that some people, some places they do, some jobs do, for like a grease or parts of this stuff, so they change this law. But in my understanding, I guess the job I'm going to do, that the place I'm going to have is totally neat and clean.
So that I'm clear,
Mike.
you said a few minutes ago, I believe that there was no shop, but in the whole issue here that you're going to have a dealership with a service facility next door?
No service. Because all is going to be clean title, it's coming from the auction, and it's going to sell here. No shop.
Okay, well, I think that's the whole reason you're here. Am I
Automobile
correct?
sales. Is there, I guess,
Well,
a
I
question
think-
for the staff, is there any difference between an automobile, a used automobile sales facility and an automobile repair facility in terms of this distance
There
rule?
is, and the ordinance that passed in 2018 referenced both of them with respect to the distance issue.
So either is prohibited?
Both of them are prohibited within the distance.
Okay. And then do we know how close they are?
I will check and see if that's on the application.
Okay.
But the issue is that there's something else within that distance. There's another auto repair shop or sales shop owned by someone else? Okay.
There's another auto repair shop.
Other
in
repair shop is
13?
on the other side, yeah,
Okay,
almost.
that
Yes,
answers
it
my
is.
question. Okay, I thought that the issue
Yes,
here
it
was
is.
you were building both.
It's a repair
facilities.
shop,
Okay.
not car lot. It's a repair shop.
It's a repair shop.
Repair shop.
It's next door, I would assume?
No, it's not next door. It's almost maybe 600-700
Okay.
distance.
Thank you.
You're welcome.
All right. Is there anything else that you'd like to add?
No, I guess that's all I need to mention regarding this matter because, that's the only thing is very important to me. I know they changed the law. I didn't know that. But when I received this letter, I paid a lot of money for this property. I spent money for the floor plan. I spent time, and it's cost me money.
Any other questions? All right, we will close the public hearing. It seems like that there is maybe some part of a case for a variance, but not necessarily for an item A, and I don't even know if a variance would pass without, he'd mentioned the new council member being supportive, and if there's, extraordinary community support, including the council member, in a situation like this, sometimes a variance is considered by the board. But in terms of the general question, was the zoning administrator correct? I don't see evidence that the zoning administrator erred. But I'm empathetic to the situation because, when you buy a property, you check it out. But almost 2 years had passed between the first question to codes and the application for a permit. And in that time, the law changed, and that was just, I think, really unfortunate. And I'm very empathetic. And like I said, I can't speak for everybody else, but again, with given the situation and with substantial community support, specifically the council member, I might be willing to consider a variance, but that would be a different type of request. But, and again, I don't know that there are 4 people on this board that would agree with me on a potential for a variance, but I don't see in item A, the zoning administrator erred being anything just that I could support.
Were we able to ascertain how far it is? And if you can,
That is not included in the application, so I don't have that information in front of me. I just know that it's closer than the legal requirement.
that's, so the measurement was done and it was by the administrator and was correct, basically.
Correct.
Thank you.
Can I mention something?
I'm sorry.
Can I mention something?
Well, no, I think the public hearing's closed, and so unless somebody has, I think that the public hearing's closed, so is there any other thoughts or comments? Avenues for, yeah.
I'll make a motion that it's not, oh, I'm sorry.
Well, that's fine.
I was going to just say, I think there might be a different legal way to move forward, but it's probably not at this board. But there's, I don't know, something, the vested, see, I'm not an attorney, but I would talk to an attorney about a way to maybe move forward in a different, at a court or somewhere else.
So is that a motion?
So I'll make a motion that we deny.
That the zoning administrator did not err?
Yeah, that the zoning administrator was correct, and it's, actually, I don't think it's properly before us.
Is there a second to that motion? There's a motion, there's a second. Any other discussion? All in favor, say aye. Aye, that motion passes. Again, and talk with the codes folks. So like I said, a variance is another approach, and it may or may not pass, but the codes folks can help you on that.
Thank you.
Next case, 2019-381, involving property at 265 Old Hickory Boulevard East. This is a request from Sidewalk Requirements to construct a multi-unit development without building sidewalks or paying into the fund. Is the applicant here on this case? Yes. Before you is a zoning map showing the zoning of the property as RM20. Area photo giving you a sense of the surrounding area. Site plan submitted by the applicant before you now, and finally the picture showing you the current conditions of the property. Is there anyone here in opposition to case 381? Seeing none, the appellant will have 5 minutes to make your desired presentation. Please be sure to identify yourself by name and address.
Matt Lackey with Reagan Smith, civil engineer representing this project. So we deferred from last meeting to meet with staff trying to get on the same page. We were originally told that it was going to be recommended for approval on August 7th, and then 2 days before the hearing, we found out that it was recommended for disapproval. So we met with staff and explained the hardships that we have for this, and as such, to meet the standard for the major collector street plan would alter our driveway to be 17% grade, which is not acceptable for fire access road. Maximum is 10%. We would also have to relocate approximately 320 feet of public sanitary line and approximately 300 feet of public storm line as well. We would have to relocate one electric pole, require grading easement from our neighbor. We would have to modify the existing detention pond and build new concrete retaining walls.
So, Matt, tell me what happened with, because the letter I have says basically work with Metro Public Works and Metro Water to develop an alternative sidewalk design that could alleviate some of the concerns. And it sounds like there's some pretty serious topography and site issues. But tell me how you exhausted working with Public Works, Planning, and Metro Water.
Yes, sir. We met and came up with an alternative. We did two different alternatives. And the one that was the most generous from staff, we still have a 13% grade change, and that grade change occurs on a curve. So we have reached out to Metro Fire and have not received any indication that that would be approved for fire truck access routing. And subsequent to that meeting, we actually got confirmation from both Public Works and Metro Stormwater that they do believe it's a hardship once we laid out our case. So, you know.
So when will you hear from the fire department? Because I'm wondering if this is, I think you're saying the fire department may not be okay with the.
Well, per the code, it's not. That's definitive.
Okay.
All right. So the authority have jurisdiction, can approve more, but this is exceeding even, they said 10 to 12% on short straight runs. This is not a straight run. It is a short run, but it's 13% grade. Additionally, that grade change creates a total cut across the drive in excess of 1 foot. So the proposal here is to add additional units, but maintain the 20 existing units that are there. We have one access in and out. If we have to do 1 foot cut across the entire drive, essentially we're kicking out all the tenants and until that construction is done. They have no way to get in and out.
Okay, thanks.
So, I mean, we met, once we laid out and showed them the grading, the infrastructure, I left that meeting and side discussions afterwards were both the Stormwater and Public Works recognized truly that we have a hardship there.
Was there any discussion about paying into the in lieu fund?
Oh,
Is that an option?
Yes, per my last email to Ms. Lamb, they fully are prepared to pay the in lieu of on the front. Now, there's also a multi-use path that got tagged on the backside on State Route 245, and I wasn't even able to get clarity on what and how that was to be constructed. I mean, that's a state TDOT route, and per the grass strip and the 12-foot multi-use path would put it dead center of the roadside ditch. So you're talking about taking a roadside ditch on a TDOT route and putting a curb and gutter on it, or at least modifying the drainage. And I just don't think that's appropriate, and I couldn't get clarity about how we even go about doing it because it would have been a first along this entire strip.
So so you're all proposing that to pay the in lieu for the 265 Old Hickory Boulevard East frontage?
Yes, sir. Okay. But we would apply to not build nor pay the in lieu of for the TDOT right-of-way 12-foot strip.
What's your frontage on that Old Hickory side? It doesn't look like
Which Old Hickory?
The narrowest Old Hickory. That's the side you want to pay on, right?
Yeah, I think so. It's probably 100. I didn't bring my scale, but it's
if you don't know,
120, 150 feet, something like that.
But you don't even have access to the other, right?
We do not even have access, and
So
as you know,
there's no driveway or any access to that state route. So
that is correct. And as you know, I mean, there have been cases where they've gotten approval without even paying in lieu of when you have double frontage, and
Right.
these clients are offering to pay in lieu of on the portion that they do have a driveway on.
Okay. Any other?
I'll just say I like that you said that you didn't have your scale with you. I have one of those. I don't use it often, but it was refreshing to hear
I
about
actually
scale.
meant to bring it, but I had a lunch encounter before. Yeah.
Right. Any other questions? Anything to add? Did you have anything to add?
I really don't.
Okay, then we'll close the public hearing. To me, this is one where someone's really exhausted all options, and the fact that they're willing to pay, I think, is certainly reasonable. So I'll move that I see nodding, so I didn't want to cut off discussion. I'll move that we approve the variance for the sidewalk requirements, provided that the applicant pay the in lieu fee only on the 265 Old Hickory Boulevard East frontage, which is their access frontage.
I'll second it.
I have a motion, I have a second. Any discussion? All in favor, say aye.
Aye.
Any opposed? That passes unanimously. Good luck.
Next case, 2019-399. Are you the applicant?
I'm not the applicant.
We need the applicant to come up first. This is involving property at 1816 Owen Street and 1817 10th Avenue North. This is a sidewalk variance request to construct 2 single-family residences. And the request is to pay into the sidewalk fund for the frontage along 10th Avenue North.
And also give the right-of-way on Owen. I think that was.
That was a recommendation by planning, what the appellant had agreed to.
Yeah, so we're in a situation where the applicant has agreed to planning's recommendation and someone objects. And
Correct.
so we understand so basically tell us what you're trying to do, but I think what we know you're trying to do is what planning recommended, which is pay on 10th and provide the right-of-way on Owen. And so
That's
if you want to tell us what you're doing and
Sure.
what that means, that'd be helpful. Thanks.
Absolutely. My name's Chad Harris. I'm representing the owner and the builders. So the 10th Avenue house is facing 10th Avenue. The Owen Street house is facing Owen Street. There are currently sidewalks on 10th Avenue, so we didn't feel the need to build new sidewalks that would be a different overlay, so it would disrupt the current flow, so we just wanted to leave those alone. And then on the backside, there are no sidewalks on Owen, so we didn't want to add sidewalks where it would just be grass on someone's lot, grass on the other person's lot, and then sidewalks. So we filed for this, and we agree with the recommendations, so we don't have any objections. We just want to move forward and pay the in lieu of fee for the front and not do anything on the back.
Is it for some folks, they say it's cheaper to build on than to pay the in lieu fee, and on Owen, is there topography issues on Owen that would make it more expensive to build the sidewalk, or is it just the disruption of the flow?
No, I mean, it is more of the disruption of the flow and just kind of being odd and strange looking, more than anything, really. And the front side, it kind of looks better to have the original sidewalks when the original sidewalks are on both sides. Otherwise, you're just kind of creating, a different look for one lot. And we didn't think that was necessary either, especially if it were have to fall under the new overlay, which would ultimately zigzag.
Right.
And then you're creating kind of a difficult situation for bikers and potentially walkers too, so.
Okay, great, thanks.
Thank you.
Any other questions for the applicant at this point? All right, we'll hear from the opposition, and when you come back, you'll have 8 minutes for rebuttal.
Thank you.
Thanks for the opportunity to talk today. My name is Ted Chapin. I live at 1820 11th Avenue North. I am directly across Owen Street from the property adjacent to Mr. Harris's development. I ran for council the last 6 months. I'm well aware of what this is in regards to, the sidewalks and whatnot. Owen Street is not a street. That is the problem. Ed Kendall was not able to solve this problem for me. Fortunately, Brandon Taylor is the councilman for District 21 now, and he's a friend of mine. We're going to work on this. Between Clay Street and Buchanan, Owen Street is an alley. And I've talked to people at planning about this. Ellen Gonzalez actually did considerable research. There were several deeds for properties on 10th and 11th that describe the properties as backing up to an alley. That is Owen Street. Owen Street between Cass Street and Clay Street is a street, and it has houses facing it. I am particularly disturbed that there's actually being an address given to this property on Owen Street. I canvassed this area of the neighborhood. It is my neighborhood. I know the feelings of the people on 10th and 11th. This is the type of development that we don't want, and it is an anomaly. And I realize there's nothing we're going to do here today that's going to prevent him from doing what he's doing, but I want to bring to the board's attention this anomaly prevents cases that should come before you from coming before you because Owen Street is being considered a street. Like I said, many of the deeds for properties on 10th and 11th describe Owen Street as an alley, and it's been treated as an alley since the 60s, maybe the 50s. It's been on the city street map since 1908, but there have only ever been houses facing Owen Street between Cass and Clay Street. and we do want to do something about this. But in regards to this case in particular, and I'll make it brief because I do hope that we have a solution for this in the future, because this is going to put a lot of density on Owen Street or my alley that is unnecessary, unwanted. The applicant has the ability to build these two houses because Owen is a street, and so I'm asking that he pay into the sidewalk fund for both frontages. Even if he's not going to build a sidewalk back there, and frankly, I'd prefer that he not. I don't really like having a house looking down into my backyard. It's very disappointing. My neighbors don't like it. Nobody likes it. Nobody likes this. We want to change it. But if he's being allowed to do this type of development because Owen is a street, then I think even if it's just a minor inconvenience or extra fee to pay, that he has to pay into the sidewalk fund twice. That's what I would like.
Okay.
Thank you.
Any questions? No, any questions? Thank you. All right, we'll hear back from the applicant.
So, it seems to me that this argument's not even related to what we're really discussing today. It almost seems more of like a spiteful stab at us because he doesn't like it. We've done nothing wrong. We've done everything according to the approvals of Metro. In fact, the house that was there was condemned, and Metro was calling us for several months as we were trying to get the approval process and asking us when we were going to tear it down. So by the time it's all said and done, these two houses are going to be brand new. They're going to be beautiful. They're going to have great landscaping. They're going to have grass, and they're going to have, fences, and it's just going to be a really great improvement to the neighborhood that where previously was a condemned house, essentially. So I think that sometimes we get the bad rep because we're builders and we come in and try to make money, which there's no guarantee that we're going to make any money on this property. That's to be said. We won't know until it's all said and done with. So this is all at the risk of us. There's many developments that we don't make money on. But at the end of the day, we're just trying to make improvements. And yes, we're trying to make a little bit of money in the end as well. So I don't really, I guess, I don't understand why, he would want us to pay the in lieu of fee for the back when he doesn't want the sidewalks there anyways. That doesn't really even make sense other than the fact that he just wants to take a personal stab and hurt our bottom line, so.
It didn't actually sound like he was taking a personal stab. It sounded like he was concerned that a street that is currently being used as an alley is now going to be turned into a street. That's how I read his argument.
Right.
So I guess my question is there a house currently fronting Owen?
Yeah, the proposed plan is for a house to face Owen Street.
Right. Was there a house, the one that you condemned, the one that was condemned and you tore down?
No.
So this
No.
will be a new house facing Owen?
Correct.
Okay,
Yeah,
that was my question.
Yeah, sure. But this was approved by Metro to do, which there are other houses that are currently built that are facing Owen. And I know some people may not like it, but at the same time, it's making Owen Street a better street, and it's making it feel more like a street versus an alley. And I mean, that's just my personal opinion, and that's my take on it, but it's kind of cleaning the street up a little bit. There's another one further down that's facing Owen, and the more of these type of houses that, I mean, the other option would have been to build two side by side, right? The tall skinnies, the infill. That's the same density. So there's really not a density argument because you're still building two houses. They're just side by side with two big backyards. This is the same amount of density. It's just spreading those houses out and giving each, owner a different space. So anyways, regardless, I mean, that's another argument. That's not even, I don't personally think that's relevant today. And so, my condolences to, the one in opposition, but I don't really understand how he could come in and, change y'all's recommendations just based on his anger towards the previously approved issue.
Right. And,
What's your front, oh, I'm sorry.
I'm sorry, what'd you say?
What's your frontage on both these? It's 50 foot or 100 foot?
This particular lot's actually 45.
45. So you got total of 90 frontage, correct? Okay.
Right, which is the main reason why we didn't want to do the side-by-sides on this lot, because it's not the full 50, so therefore they would have been even tighter. We've done plenty of those side-by-sides, but this particular lot felt like it made more sense to do front and back because it gave the two houses kind of their own space.
Okay. Any other questions? Is there anything that you have to add? Like
That's
to
it.
add?
Thank
All
you.
right. We'll close the public hearing. I mean, thoughts?
Well, I actually have more of a question for staff is Owen Street a dedicated Metro street?
I don't have that information in front of me, except to say that the application was reviewed. I believe planning was involved with this. With respect to an addressing issue, that's a totally different department, so that's not codes. So I can't speak to that right now.
Understood.
So I'm surprised that,
Well, I was just going to say, I'm looking at the planning department's variance recommendation in the packet, and it describes 10th Avenue North as a local street. It describes Owen Street as a local street. So I would guess that it probably is a street.
Well, and I can't recall, I mean, there are an awful lot of situations where we have applicants come wanting to build on and build in a way that is, again, perfectly within their right to build, but odd compared to what maybe the neighborhood is now or what folks have thought about building. And a good example is the lot right below the one in red, where there's a line down the middle of it which says it's one property, but there's really two lots, and we see people coming in all the time and building two houses on each of those, and have neighbors that don't like it because it doesn't make sense, but that's how the law is written. And because of the growth in Nashville, people are pushing those questions, and council sometimes catches up quickly, and sometimes they don't, and sometimes they don't catch up because they think it's okay for the folks to follow the current rules. And so, from a neighbor perspective and what's going on, I'm empathetic, but I also don't know that that's the question before us. It's the sidewalk and what they should do. And there's just a long history of us following planning's recommendation, especially on parcels that have two frontages. And so I don't have a problem with, personally have a problem with planning's recommendation that the applicant has agreed to, but others may feel differently.
yeah, I almost always agree with planning, but it seems to me like, especially when you have only 95 feet of frontage, that usually what I see is they recommend that you contribute on both sides, and I think it's a very fair argument. I don't think this gentleman is being vindictive at all. I think he's making a very fair point, which is you're putting in two houses. They're both considered streets. I know that I have, most of the time it seems to me like planning recommends you contribute on all frontage, and I think that's fair here, and that's where I come out on it.
Okay.
And I agree with Mr. Pepper.
Well, is there someone?
The motions are down there.
Yeah, someone can make a motion and see where that goes.
Can I say something?
No, the public hearing's closed right now. I'm sorry, sir.
Even if we wanted to just.
I'm sorry. The public. Yeah, everybody's had a chance to say, and I think we fully understand the issue, and so the public hearing's closed.
So I will move that the applicant shall contribute to the in lieu of fund for 10th Avenue North and Owen Street, dedicate the right-of-way along Owen Street according as planning recommended, and then maintain the existing sidewalk as planning recommended.
A second.
All right, so there's a motion and there's a second. Is there any discussion? All in favor of that motion, raise your hand. Any opposed? So that passes 5-1. All right. Next case.
Next case, 2019-408.
Oh, yeah, and
Both Tom and I have to step out at 2:45. So.
Okay, so let's see, can we hear one more and then?
Sure.
All right, so,
But
I'm sorry, next case.
2019-408 involving property at 1610 Gray Bar Lane, requesting a variance from street setback requirements to construct a single-family residence. Before you is a zoning map showing the zoning of the property as RS40. Aerial photography giving you a sense of the surrounding area. Before you now is the site plan submitted by the applicant. And finally, the photograph showing you the current conditions of the property as well as up and down the street. I believe there was opposition present for this case. Is opposition still here? So each side will have 10 minutes. Mr. Henry, you'll state your name and address, please, before addressing the board. And of course, as always, reserve rebuttal time from this originally allotted 10 minutes.
Okay. If you would, yeah, state your name, tell us why we're here.
Mr. Chairman, Sean Henry, 315 Dedrick Street, representing Tim and Brenna Perkins, the owner of the property. With me is Chris Wiseman on my right. She's an architect that's been hired by the Perkins to draft their design plans. This request really began with a letter that went out to the surrounding neighbors by my client, and I don't believe that letter has been submitted for the record. I'd like to do that now. Essentially, it was Mr. Perkins explaining, their commitment to this neighborhood. This is their long-term house. This is where they want to build their dream house and live out the rest of their days. So I'd like to submit that for the record, if I may.
Sure.
We had a neighborhood meeting with Councilman Russ Pooley at the Granny White Church of Christ 2 weeks ago, and there was one person who came to that meeting. She resides directly across the street here on Amanda on that corner, and she left the meeting satisfied. And Councilman Pooley has now notified your staff that he too is supportive of the variance request. So the zoning code in this case requires a 40-foot setback. That's the minimum setback, 40 feet. But we have the setback averaging provision, and that requires us to look down the street on the same block face. In this case, there's only one other house to compare it to, and that's the house immediately to the east. And so the average setback comes out to 131 feet. And the zoning code states, however, that no matter what the average setback is, you don't have to sit back any deeper than 3 times the minimum setback. So that's 3 times 40. The maximum setback here would be 120 feet. What we're asking for is a reduction of that 120-foot setback to 90 feet to allow a new and modern home. And Ms. Wiseman can go into that. But before she does, I'd like to just touch on the standards by which you are to view and decide these cases. I know you're all too familiar with them. You hear them all the time. But the physical characteristics of the property are really important here. And what really proves out, in our opinion, is the shallowness of the building envelope that is there. You have a pretty much perfect square there, but the depth of the building envelope is very shallow relative to the adjacent properties here. So there's specific conditions here that are unique to this property, unlike the others, and we'll dive into that. But as you can see on the screen here, and appreciate staff pulling that up, this property is not as deep as the property adjacent to it. In fact, the existing home there is about 20 feet off of that rear line, which is the minimum 20-foot setback. The home to the east is about 50 feet off of their rear property line. So they have a deeper lot than the one we're talking about here. This hardship is not self-imposed. There's no financial gain here. Certainly not the basis of this is certainly not a financial gain. There's no injury to neighboring property. One of the criteria here is that the variance, if granted, shall not impair an adequate supply of light and air to the adjacent property. By granting this variance, it'll allow the new home to slide toward Gray Bar Lane, increasing the amount of air and light to the adjacent property there on Amanda Drive. No harm to the public welfare, and there's no master development plan that has to be reviewed here. So Ms. Wiseman has looked not only at these two properties side by side, she's also looked down the street in both directions at the existing conditions. And even though the properties on the south side of Gray Bar Lane are not in play here, they're not part of what the setback requires because it's all on the same block face, in this case the north side. She nonetheless has taken a look at those properties, and if the staff can pull up the other diagram that was submitted, Ms. Wiseman would be able to explain those relationships if you all have that. It appeared in your packet, so.
They'll have it in the packet. It won't be in the presentation, but they have it in their packet.
Okay.
Okay.
So I'll just, so it's this one, if you can pull up this comparison of the street, there's a variety of dimensions that Ms. Wiseman's going to
And
refer
so,
to.
I'm sorry, maybe I'll address, if you would state your name and address, and then.
Yeah, my name is Chris Wiseman. I'm the architect for the client.
And then if, on this drawing that you have where you have the red markings and the house is highlighted completely in red, and then to the left you have a 40-foot and a 60-foot setback drawn, I guess, in red. Are those existing homes, that 40 and the 60?
Yes, they are.
So they already exist as 40 and 60-foot setback?
They do.
And then it's a church or some other?
It is a church, yes.
And that's the one that's 55 feet?
Yes.
Okay. And so that I didn't want to steal your thunder, but that
No,
may
not
have been
at
what you
all.
just wanted to tell me, but I wanted to make sure that I understood your drawing.
Yes.
And that everybody, I guess, is seeing.
Yes, and that's important to us, obviously, to show that there are other houses on the street that are closer. That's not why we want to get closer. The building envelope gets very narrow because it pushes back that 120 feet. You end up with something that, by the way of, what the client wants to put there, a modern home, will end up being almost as wide as the setbacks will allow from side to side. So what it would help, I think, with, if we could deepen it somewhat, for one thing, they can get a backyard that they can play in. They can have more space between them and the people on the backside, the people that face Amanda on their rear property line. But also, if you look up and down the street on everyone, even to the person that's to the east of them, everyone has double what we have for a rear setback. For a rear yard. So ours is about 20 feet now, and will be 20 feet if that setback is, contained to the 120 feet. But if you look across the street, they have 200 feet backyards. And even the lady beside is 50 foot, but people on the other side of Amanda are 200-foot backyards. So I feel like we're constrained in this smaller lot with nothing but front yard in this situation. And I think it would be helpful if they could push somewhat to the front, and that way not make the house quite as wide, make the house slightly deeper, but still give us some backyard to work with here.
Okay. Any questions?
If I may just supplement that on one point, there's trees that are depicted on the current survey. There's only one additional tree that would be sacrificed potentially as a result of this setback reduction. So I just wanted to point that out. And there's a significant number of trees in the front yard.
Yeah, I know that's not necessarily, sometimes there's a criteria for hardship, keeping trees necessarily, but I did happen to pass this lot today just by chance and didn't realize it until I saw the BZA sign in front of it, and it is a beautiful lot, and the trees really are something on that lot, and it's nice to hear that there'll only be one tree lost in the new construction. All right, anything else to add at this point?
Mr. Chairman, only, and certainly open to answering questions and save time for rebuttal, but I've represented this client on a number of occasions previously. This is not the first rodeo that he and I have had, and his wife. This is their permanent home. They're excited about living in this neighborhood. We understand Gray Bar Lane folks take their neighborhood very serious, so we'll listen to see what they have to say. But we certainly think the variance is not only justified, but is going to allow for a more reasonable building envelope and allows the new home to get further away from their rear yard neighbor, which is the side situation, the side relationship. So,
And just one quick question on the Ms. Weisman, on the chart that you gave, there were two homes that were 40 foot and 60 foot. So there are two homes within, well, 5 houses of
Exactly.
Of this that appeared to be new based on the drawing and how it was plotted that are closer. Any thought of why is that because the house, their average they ended up with a lower average, or was there any knowledge as to why?
I think yes. I don't know exactly why.
So
I think the people that are on the corner of Gray Bar and, I can't read that, I'm sorry. I think theirs is actually facing another direction. So that's
Okay. I
their
see.
side setback probably, or
Okay.
they have two fronts essentially.
But
so
the other
that's their
one,
front
but the
setback.
one next to that faces.
The one
and-
next to it, yeah, probably benefited because that's on their block and
Okay.
I don't know for a fact. It could have been there. But
So in your opinion, and I think it's not necessarily opinion, it seems factual that it's because of the odd-shaped lots and the distances between. I mean, it's just the location of this place has a strange average just because of where it is.
Right.
Okay.
Exactly.
Perfect. Okay. Thank you. All right. You will have 2 minutes for rebuttal. We'll hear from the opposition. And I'm sorry, unless you had anybody questions. Do you want to hear from them? Tell me you got 5 minutes. Let's hear from them as much, and then we may, before we have discussion, take a quick.
Sure, thank you.
Thank you. All right, you all have 10 minutes total. If, however you want to organize that, and whoever talks first, state your name and tell us, and your address, and tell us why you're here.
Hello, my name is Jacqueline Boycavich, and
Yeah, just press the button right in front of you. The red light will turn on. Now you're good
This
to
one?
go. Yes.
hello. Oh, there we go. Sorry. Hi, my name is Jacqueline Boycavich, and I live at 1617 Gray Bar Lane, which is right across from the property that is wanting to be built on. I've kind of made a little handout with some of the pictures of the street and what I think the house will look like, if they move it forward. I know that they requested for it to be moved forward to be in a line with the rest of the street, but if they do that, it won't. It will essentially cut their front yard in half, setting it much closer to the street than all the rest of the houses. We recently bought across the street a year ago, and we also built our dream house. So I know what it is to have to deal with all the zoning and all the things, and my husband and I made no zoning appeals. We bought the property knowing all the setbacks, all the zoning, and so we built accordingly. And it is disappointing that this property once was an almost 2-acre large lot, and I'm pretty sure the person that lived there before, they obviously sold the back half of their lot, and then they built on Amanda, the 2 houses that are existing behind it. That's what has made it to where they have less of a backyard. If you look
So
at
you're
one,
saying it was subdivided
yes,
recently?
that was
Several years ago.
It was a long time ago. So the house that is currently there is set back farther in the yard. But if you see one of my drawings, if they stick with the same setback to be aligned with the rest of the houses, and they keep the 40-foot setbacks on the side, they could easily build a beautiful 7,000 square foot home and still have a little bit of backyard, a beautiful side courtyard on either side. The property in the back has what we call the Green Hills fence line, which is huge trees, tons of greenery. They can't even see the house. The house is behind them that are not on Gray Bar, but on Amanda. I think they could still build their beautiful dream house, but keep Gray Bar Lane looking the way that I think we all love it to be. It's really few and far between in Green Hills where you have homes that have huge yards and beautiful front yards, and it's now becoming where everything's moving closer, everything's getting on top of each other, and Gray Bar is set apart from that in how Green Hills is becoming and how big it is being developed, and that's my thoughts. I'll leave you guys some time.
Or do I have to? Yes, I'm Mark Munson. I'm at 1701 Gray Bar Lane. I've been there 20 years, and in that time, we have fought commercial creep into our neighborhood. Okay, we rezoned probably, let's call it 16 years ago to the current one because they built the houses at the corner of Gray Bar and with the Hopkins. And at that time, we got together, went through the neighborhood, and everybody knew that we're going to zone it or rezone it to a higher, R, what is it, R?
The R40, the low
RS40. So we did that, and everybody was on board. At that time, we gave 3 grandfather clauses to 3 properties, okay? And at that time, today, all 3 have sold. 2 of them kept the setback on Gray Bar on the other side of the street to the proper level. And then one of the grandfathers was one of the ones that they referenced on a new building that happened in the last 2 or 3 years, okay? But everybody bought into the RD40, and everybody wanted to keep the integrity of the street going forward. So the individuals that had the property before, they agreed to it. The owners of the new property understand what the setback was. And from a Green Hills perspective, we like to keep the integrity of the properties the same in the setback. Because that's what makes Gray Bar a very special street still in Green Hills.
My name is Laura Lano. I live directly across at 1621 Gray Bar Lane. I've lived there my family's lived there for almost 50 years. And I feel like this property was bought with them knowing ahead of time what the conditions of the zoning were and the feel of the street. And it's true what Mark was saying. The neighbors feel very strongly about our street and protecting the integrity and the way it is. And we have fought for years to keep it the way it is, and we feel like this is a slippery slope and a domino. If this goes, we have no idea about the future, and we just feel like we've been fighting all along and still feel the same.
Hi, I'm Robert Andrews. I'm at 1801 Gray Bar Lane. I actually sent an email out to several of the other neighbors that live on Gray Bar to see if they were going to be attending today. And unfortunately, time of day, it's tough to get, cut away from work and come here to take on a challenge like what we're doing today. I'm looking at one of the emails I got back. It says, Robert, I agree with you. I went over to the lot and measured, and the house will not look like it'll look like it's right up against the street. I wouldn't mind giving some, but I'm not ready to give 30. Sorry, I can't make the meeting. That was pretty much the consensus of everybody else that, again, live on Gray Bar that I contacted. I think there was 5 other folks, households, that are against making this zoning exception. We've got a nice street. I think one of you folks said that you were on the street today. It is a lovely lot. We'd like to keep it that way. One of the nice things about Gray Bar, there's a sense of a neighborhood there. And again, the setbacks all being consistent is part of that part of the charm of the street. And I think if we start making an exception here, as you heard earlier, I think there might be some others coming down the pike. I'd like to meet the Perkins. I welcome them to the neighborhood. I'm sure they're going to build a beautiful home, but I think with a talented architect like we heard speak earlier, I'm sure she can work within the zoning restrictions that are in place now. But again, I'm like the others that are sitting in front of you, I'm against making this exception.
The council member had mentioned a community meeting. Were any of you all at the community meeting?
I don't remember.
There was one
Being
at the church down the road. I had a college event to go at my child's school. Couldn't make it at that time.
Okay. I mean, because from the council member specifically said that, that the neighbors were satisfied, the plan, there's no one that was in opposition to it. So I just take it that none of y'all were there.
I don't think Russ took the pulse of the full neighborhood.
Yeah, I don't think, yeah, again, I don't remember the meeting. I've
I'm
traveled.
not aware of it.
And I don't remember getting a letter from the Perkins either, for that matter. My wife.
I understand that, and we've got two members that are going to have to take a break in just a minute, so we may have to take a break at the middle of the case. So just keep me posted on that. But we will hear the case before the day's over. But and I understand that you all have concerns about precedent and, if the domino,
Sure.
And I get that as a neighbor, and for me as a member of this board, I see basically 4 properties on that street that have potential to have a closer setback, and 2 of them already have that. And so to me, it's this one and the one next door, the only 2 that have any potential for this. And so tell me, what greater fear is there besides this house and the one next door to it that would be a potential domino? Because it seems like 2 of the 4 have already fallen, and this would be the third, and the other one next door, if it were sold and someone bought it. I think the case that they would make would be the same one as this. It's a very different, unique lot compared to the rest on the street. In fact, everyone that lives across the street is very fortunate to have a giant, not small shaped lot. And I know the street is a beautiful street. I get everything you're saying, but help me understand why it's a greater threat to the neighborhood than just a single house.
Well, I think if I sold my home and somebody came in and bought it, and they had a nice architect and they had a wonderful plan, and all of a sudden they thought that maybe if we push it closer to the street, it'll be more grand. I mean, I think that's one of the risks here. I mean, who knows what the future holds?
Right. But there's nothing in that. There's nothing in that criteria. And I'm not trying to be argumentative. I really am trying to understand and totally get what you're saying. But if it were any lot across the street, there's no. The lots are all the same. There's no argument to say it should be closer. But this is. Those are big rectangles, and this is a square.
We understand that. The house that's just west of it are 2 lots, and just west of that are 2 lots. Okay. So if I'm looking
at that one, is it to the right or the left?
It's
here. Is it this way?
One closer, yeah. It's this way.
Both of those houses used to be one full lot.
So,
this way.
Yeah. So those 2 are 2 1-acre lots. Okay.
And it used to be 1 2-acre lot.
100-year-old houses. Okay. That doesn't mean someone's not going to come in there, bulldoze the house, and build something new. Okay. And that's our biggest concern.
Yeah, but I guess I'm just saying I don't. And again, it may not be on this board at that point if they come and ask for a variance or some sort. But to me. The argument is this is an odd-shaped lot, and based on its neighbors, I see the lot in red as odd-shaped compared to the ones across the street, and even compared to the ones, they're, on the block. And so, I guess I just the argument that I hear you say about the big rectangle, it's never going to be an odd-shaped lot. It's actually a very big
Correct,
what
but
is,
if you see
what
the
is consistent?
property line,
Yeah,
if you see the
look at the
property,
houses, they're all the same line. You
go
can
to the
draw a
shot,
line.
go to the shot that shows the property lines there.
Okay.
That house is right up on their property line.
Okay.
Mr. Chairman, point
you all
of
need
privilege, I need
Okay.
to.
Is it, I'm going to, we need to take a break, so I'm going to pause this hearing. When we come back, we'll have 2.5 minutes for the opposition to make to wrap up and ask questions. You all can go to your, and then we'll have the rebuttal time for the applicant, because and the timing actually is pretty good, because I really don't want to have a break and then have that time between what you all have to say and the applicant again. So if we think it'll be 10 or 15 minutes, we'll wait till make sure everybody's back. But we have two attorneys, and they both have legal calls at 3 that they can't get out of, and we didn't want to postpone the hearing in general, so we just have to take this break right now. So, but you can let's don't anything that you have to say about the case. We need to have everybody here. So let's just keep that thought. Write it down. Well, I would write it down because I wouldn't remember it, but you probably will remember it. But hold that thought until we get back. To case 408, and know that you had been discussing the characteristics of the neighborhood, and you have 2 minutes and 36 seconds to add anything in addition or to answer any, well, the questions from the board don't count against your time, but if anybody has any questions or if you all have something that you would like to continue to say.
I guess I don't have a lot of time, so if I had to just make one last point, I know a lot of what people have been talking about is some of the houses on Amanda and some of the houses on the side streets, but I think what the neighborhood and the people that were here, we're representing Gray Bar Lane and the area that we live in, and the way when you drive down the street, you look from side to side and you see these large, beautiful front yards and all the houses line up, and we are very blessed to live on this street and to have the kind of neighborhood that I feel like is fleeting in Green Hills, and I just hope that you'll consider everything that we all said and the feelings of the neighborhood when you make your decision.
The other two had to leave. I'm going to have to leave also here shortly, but we were talking about Councilman Polly's meeting, and I'm sorry that we weren't there to voice opposition. Mr. Munson actually texted him and asked him, and I don't think he got a response, how many people were at the meeting, how many Gray Bar residents were at the meeting. As I said earlier, I surveyed several people that weren't able to come today who live on Gray Bar, who oppose this variance. And again, we were talking before the break about that photograph up there, and you can see the setbacks. And if you pull that back and saw more of Gray Bar, our stretch of Gray Bar, most of the houses, have a very attractive setback. As you go up, it's just part of the charm of the street. And if you pull the house in question here up 30 feet, it's not going to fit. And that's my exception, and that's again what I surveyed the folks who live on Gray Bar. That was kind of their exception also.
Okay. Are there any other questions for the opposition? All right. Thank you so much. We will hear back from the applicant.
Thank you, Mr. Chairman. I just want to make 4 points, and then Ms. Wiseman will speak. The public notice that went out for this meeting contained the invitation to the community meeting that was held at the church. So anyone that got a notice for this meeting also in the same envelope received an invitation to the community meeting. The rear yard is the driving force behind this request. Without front setback relief, the house would be built from side yard to side yard. So it's going to get very wide side to side. Third point, these other homes across the street, very deep lots, they have about 200 feet of rear yard space. We've looked at that. And the homes to the left similarly have about 200 feet of rear yard space. And then going down to the other lot that's about the same size of this property, they've got a 78-foot rear yard. And what we're asking for here is roughly a 50-foot rear yard by the reduction in the front yard. And then finally, there's no precedent here because there is no other lot of these dimensions that doesn't already have a house on it. So this is a unique piece of property. It's unlike the surrounding properties, and we submit there's justification here for the variance. Thank you.
I would just like to say that to address the neighbor's concern that the house will not get bigger because of this front setback reduction. The house will stay the same essential square footage on the first floor regardless of whether we get the front setback or not. What will happen, it will be a more proportional size width-wise to what's elsewhere on the street. If it's required to be pushed back and we have no backyard, it will get very thin and skinny and very wide and will actually be closer to one of the neighbors here represented than if we get the setback reduced. The other thing is that all of the people that are here today from across the street, not all of them, but some of them are not even to the 120 square foot setback or 120-foot setback.
Do you have any data at all on how far those are?
I have, so just measuring off of the Metro thing, I have 1701, which is the house directly across the street, which is 1619, looks like to be about 116.7 feet front setback. The one directly to the left of that would be 119.6.
So your testimony is, if I'm looking at this picture, make
Yes.
sure, all right, I've got two screens, I want to make sure we're all looking at the same thing.
Exactly.
So your testimony is that the ones that are directly across the street from your property, if you drew a line straight across, they would be
Anywhere
approximately
from 116 to 119 feet off of
Are there
front
any
setback.
Are there any of those four houses across the street that are further back than
Yes.
120?
Going down the street, two more houses would be 123.
So if you took an average,
And then going towards Belmont East is about 125. So yeah,
so an average of those across the street, you're saying is approximately 120
or less.
or less?
Yes.
And so, and you're asking for 90, and then 120 is
120 is the minimum.
what you're required?
That's
Okay.
what we're required.
Close to 120, or, 116, 120, what was the other?
Right, but
Okay.
I think I was making the point is even though they have a much deeper lot, they still don't seem to be the whole 120 that we're required to be, and we're so much less a deep lot.
And their rear yards are about 200 feet. And that's really the critical point here.
So I guess, I guess the only other question is, you have, I know you want a 50-foot backyard, and I appreciate that. I would too. I also understand the neighbor's issue. And so, is there, and it seems like that part of that 50-foot backyard is a pool that's having a pretty big impact on this situation that we're in, because you want 20 foot from the line for the pool, and then you got another, 15 feet it looks like, or so to the house. And I guess is there any room for manipulation in terms of, a rear setback and a squeezing there that would get you, closer to 100 or 105 feet than the 90?
Yes, I think we could give on the back, rear setback some. I wouldn't want to reduce it the full 30, but certainly 20.
I don't know where anybody else is, but just again trying to push the question to see where the true where the difference between this is what we'd like and where does our true hardship actually kick in. Not that there isn't a case for a hardship in general on this one, because it was originally thought that was the case. I put it on the consent agenda thinking that there was a case there, but I appreciate the neighbors and their concerns, and I think that there is validity to some of the things that they're saying, so that's why I'm asking that. Are there other questions?
Is there some intermediate area, I guess is what I'm trying to get to, and I think, Mr. Chairman, you were asking that question, and I'm maybe late coming into understanding what the question was, and I finally figured it out.
You may ask it a lot better than I did, and I'm a lot clearer.
Well, if we were not dealing with taking the wanted 90 and where we're presently sitting, and I understand, I'm like Chairman, I do like the idea of a bigger backyard just because it's a lot nicer, but is there some in between the 90 and
105?
Yeah.
Split the difference?
Yeah, to me, and I would be much more, given the neighbor's concern, I don't know visually how, I think the difference between seeing a house 90 feet versus 120 is probably noticeable. It may be noticeable between 105 and 120, but probably much less. Half is less, I don't know. So that's why I was asking. And so, it might require, coming back to ask for a rear setback variance for the swimming pool, but, and I can't speak for everybody else, but it seems like there's an established hardship in terms of lot size for that, but that would maybe be another question.
Is it a hardship, or is it a self-imposed hardship based off the proposed plan? That's my question. I understand that this lot is different from the other lots, but I also understand that a lot of the houses facing Gray Bar sort of fall within a 116 to 123 range of a setback from the street. And so I'm wondering, is this hardship unique to the property, or is this hardship created by the design of this home?
Well, and that we may be getting into discussion, but I would say that there's not a square lot that has a house other than the two that are the older homes that are existing that are that far back and they have no backyard. But every house that's 120 feet has more backyard, including the houses on the existing block. So that to me, the only case they have for a hardship is the fact that they're lot square and not rectangle. And whether this board may say that's enough for a variance, it may say no, but I think to me that's just the case. It's a square lot, the others are rectangles, and that is dictating their desire to move forward. And and they're just saying that the other two rectangular lots down the street already have houses that are much closer than they're even asking for. The house to the right on this one, to our knowledge, hasn't, I don't know the condition of the house, or if it's a new house, if it's an old house, if, I don't know that, it hasn't come before us. So there's only 4 lots like this on that, in that kind of 2-block range that we're looking at, 2 of which have houses closer. So, I mean, I think that's just their case. But we may agree or not agree. But you're right. I mean, their choice is dictating, some of what they want, but their choices aren't unreasonable to the street. I mean, they're not asking for a radically bigger house than's on the street. They're not asking for a different style or a different anything. I mean, if you look at that house, it's what everybody else is building. Well, how do you build a house on the lot that they're talking about? Does it require you to move a little bit forward or not? I don't, that's what we have to decide in a few minutes, So I don't know that, like I said, we may have just started our deliberation before we finished asking questions, or at least raising the issues. But I'm sorry, is there anything that you all, since we clearly moved to the next phase publicly, and I apologize for that, but is there things that you would like to add?
Only to reiterate that Ms. Wiseman, through her professional expertise, believes that she could design a home that would be fitting with a setback reduction of 15 feet instead of the 30 feet.
Okay. Awesome. Any other thoughts or questions for the folks? We will close the public hearing and discuss. Thoughts?
I want to make sure that I heard correctly that what we sort of asked the questions on, there is some middle ground between the coming to 90 feet and there's some in between there is what I just heard. And I felt a lot better considering the opposition from at least a number of the neighbors.
Yeah. Well, and, and to me on paper, I mean, I'd put this on the consent agenda with my meeting with Emily. And again, I talk with the code staff and we look at the issues and we say, is there a hardship? And would it be likely to pass without, if there's no opposition? And I think if there was no opposition, this is something that might be likely to pass because of the nature of the lot. It is 3 out of the 7 lots that are on that two-street block are these squares. They're odd. And, so you've got, it is an odd-shaped lot. And yet, the reason it's not on consent is because the neighbors came and opposed, and that's important. And I think that matters. And so I do think if we grant a variance at all, it would be that compromise variance of 105 feet instead of 90, which I think is, to me, that's reasonable. I think it's respectful of what the neighbors are trying to do, and I don't have a problem with the 105.
What? And we didn't ask this question, and it hasn't come up, but what about foliage being required, trees or what have you, that might match in? I know that that's sometimes discussed.
This is a heavily wooded lot.
But not in the front, where we're talking about moving.
Oh, I think they testified that the back, that one of the
back has got a ton of stuff.
Yeah, the neighbor had said that the back, and so I think to me their testimony was even moving it 30 feet front, they would lose 1 tree. So I will make the assumption that moving it 15 feet would either keep that tree or not. Either way, they're going to still lose the 1 tree.
They'll lose 1 tree, but requiring additional trees maybe to conform with.
Well, I had the luxury of driving by it this morning. It is an extremely wooded lot in the front, and it is really a stunning piece of property. I mean, the red sign caught my eye, and I thought, wow, that's a really pretty lot. And so the fact that they're only losing, 1 additional tree that they might have, I think is admirable. And it may mean that the 15-foot back is, would keep that. I don't know, but
I don't have a problem with 105.
Is that, what are you thinking?
Well, looking at the zoning code, I agree with
getting
you.
the mic on.
Oh, yeah, I think the two things that I'm dealing with are, and your point is this is a unique property, and I agree. The code says one of the standards is the specific conditions cited are unique to the subject property and generally not prevalent to other properties in the general area. So, I mean, if you look at the lots facing Gray Bar, there are only two. They're the square shape. But if you look behind this lot, there are 1, 2, 3, 4, 5, 6 others. So I guess it depends on what you consider to be the general area. And I think to some extent we do have, it's our responsibility to interpret that.
Yeah.
And I think you're saying the general area would be, you're considering the general area to be the frontage on Gray Bar.
I would say that, to me, the general area are the properties that dictate the variance that we're being asked to judge. And those are the neighbors that face Gray Bar. And so if it were, hey, I want a lot size variance, then I think it might be more, hey, let's expand to what is the two or, even go to a street. I mean, the way I've judged that for consent, a lot size variance is, well, what are the houses on the block? What are the houses across the street? Is this a neighborhood that is all 8,000 square feet and this one is only 7,800, and, it was a line difference.
And I think that's fair. I think that's reasonable.
But now, I don't know, I mean, again, while there's 7 of us, you can pick another way to look at it, but I think that if you look at what caused the line to be at 120, and is this property different from those others that caused that average to be, that's where I think you say, well, is this unique or not unique? And, the others behind it, they face a different street, and so, they're going to have a different average and different conditions, so.
I tend to agree with you on that. And I think by saying other properties in the general area, that gives us some discretion. But the other issue that I'm thinking through is the self-imposed hardship. And whenever we have these situations where it's a house to be built and somebody essentially buys a lot to build it, I think that really comes into play, because what you're planning, I mean, it's almost per se self-imposed. And so I would not be okay with the 30 feet.
Yeah.
With the 15 feet, I don't know. I'd probably have to hear from other people. And I think the strong neighborhood opposition to this can't be ignored. And even though the other lots may be rectangular, I get what the neighbors are saying, which is whatever the size of our lot, we're all aligned in a certain way. And if a variance is given here, that's going to be noticeable, regardless of what the size of our lots are. So.
Yeah. Well, and I guess that because of the neighbors, I'd agree with the 120, the 90 not being appropriate. And that's where I think, well, does the odd shaped lot, I mean, I think 105 is okay, and mainly because it's, and the self-imposition is probably why they don't get 30, but it's, this isn't a family that divided the lot, and the tree line at the property line, to me, suggests that it happened a pretty decent little bit ago. And so, in that sense, if this person had divided the lot and then claimed hardship, I think I would have been skeptical. And we've had cases like that where it's like, well, no, you created this because you divided the lot. But this isn't the case here. So, to me, that's just why I think splitting the difference on it is not unreasonable, and I'm okay with that. But others may not be.
I mean, I sort of agree with Mr. Pepper in that I think that this is sort of self-imposed. And then I also found it compelling that one of the neighbors said that they built their dream house recently and they didn't ask for a variance, and now granted, I don't know what's behind them,
Yeah.
but they're across the street.
Well, they're across the street on that 120 foot back and still have the 200 feet behind,
Exactly. But I don't know, I just think that I'm sort of struggling with that too, whether, yeah.
And I guess the question is, well, I can ask it, or we can make a motion and see. Are you struggling with it enough that you are not comfortable with the 105 feet, or, and like I said, and we can I can make a motion. It may not get a second. And then we can just see, because sometimes when you have to vote, it forces you to know, well, how do I really feel about the struggle? Right. I mean, can I live with it, or no, I can't? And that's sometimes how we get to that.
Mr. Chairman, can I just clarify one point? The 15, if I may, the 15 feet is comparable to the depth of the lot to the right. Okay. So that's the only property that is calculated for purposes of the average setback. And so when you compare, the depth of that lot is right at 15 feet. We're simply saying another justification here for the 15 feet of relief is due to the fact that the adjacent property has another 15 feet to work with already. And that relief would be comparable to how deep that lot is.
Okay. All right. Thank you. Well, I didn't open the public hearing, but I'll close it again. You're fine.
Are you going to give the other opposition another shot?
Well, I think it was a clarification. I think that was clarification on the fact that the lot next door, and I think on one of the charts that you see, if you look at it, there is a jet there to make that the same.
How much if we went to the 105, would that give them the back wall?
Well, again, not the architect, but it looks like to me like there's on the plot, the plot that they have is there's a 20-foot setback, a pool, and then maybe 15 feet to the house. They talked about a 50-foot backyard, and that would be a 35-foot yard that would allow them, a 10-foot setback. It would have, yeah. So I'll go ahead just to see where we are and continue the discussion. But I will move that we grant a variance from street setback to 105 feet. Have a motion and have a second. So is there more discussion?
Well, yes, I think it'll probably be helpful for me to discuss it. I think it's a very close case. But where I'm hung up is I think that they could still build a really nice home, comply with the setback, and that when it's a really close case like this and you have the kind of neighborhood opposition that you have from neighbors that live there, I could not vote for it. So.
Okay, and totally fair.
I'm struggling too. I don't mind saying that. But I don't always want to say no.
Well, all right. Well, there is a motion on the floor. There is a second, and so we will vote and just see where we are. So, all in favor of the motion, raise your hand and say aye. 3. All opposed?
I didn't vote. I'm not sure if I can. Am I able to vote because I left for part of it?
Yeah, I believe you missed part of the public.
So I can't. Yeah.
All right. So that is 3-2, and so is there anything in the middle?
The board could make another motion to see if it prevails, or the board can leave this motion on the table for 30 days, and Ms. Chappell would have an opportunity to vote.
Okay.
We like that idea.
All right. Is there the best thing to do is to put this on hold? Okay, and that's fine. Okay, so there is a motion that has 3 votes, and that's for the 105-foot variance. It takes 4 votes to pass. We have 1 member that's out that has the ability to watch this hearing and vote at our next meeting. And depending upon what she does, we can either reopen the hearing or just have a vote on that motion.
Well,
That would also give Chris.
I'm sorry, your mic.
Is it
There,
turned
it's
off?
on
I
now.
never know with these new ones. That would also give you a chance to watch it, and so we'd have 2 more votes on it.
That's true. Okay. Great. All right, so we will continue with the next case. Good luck. Thank you.
Next case, 2019-412, involving property at 4122 Moss Rose Drive. Is the applicant here on this case? So this is a request for a variance from rear setback requirements for an addition to a residence, an existing residence. Before you is the zoning map showing the zoning of the property is RS20. Aerial photography giving you a sense of the surrounding area. This is the site plan submitted by the applicant showing the existing house and I believe where the proposed addition will go. And then finally, the current conditions of the property. Is there anyone here in opposition to case 412? Seeing none, the appellant will have 5 minutes to make your case. Please be sure to identify yourself by name and address.
Hi there, my name is Jackie Klaber, and I live at 4122 Moss Rose Drive. So try to keep it brief. I know that last one was keeping us longer. So we're just asking for the variance on the back. As you can see, the shape of the plot where our house is that we bought 2 years ago is very unique. The most unique part about it is that there is now kind of defunct road that used to be where the ferry went across the river. So you can't really see exactly on this map, but on the other side of what looks like the road at the end, that just basically backs up to the Cumberland River.
You're talking about McGavick, what's listed as McGavick Pike?
Correct, yep. So where the words are, existing deck stairs down that, that part. So basically that, if you kept going down that, quote, road, you would basically run right into the river.
But is it, do people use the road or is
No,
it?
it's, the city has put up a barrier kind of about where the proposed deck stairs is, where you cannot use the road anymore.
And then what exactly and I'll tell you that the reason, you to me, you were kind of potential for a consent agenda because you have a strange shaped lot and I didn't know what McGavick was, but I couldn't tell from your drawing just exactly what you were going to do because you talked about using the existing patio, but then you drew a line about, new space. And so tell me what you're trying to do.
So yes, where that existing concrete patio is where the addition would be, and then that extra space is going to be a deck.
That's what wasn't clear.
Gotcha.
Okay, proposed uncovered deck. Now I can see it, but I couldn't see it on my little.
Sure.
On my
So there's another, I brought a picture that might be a little bit.
That'd be great, sure. You can hand that to Jessica and she'll pass it around to everybody.
So the nice thing about putting the deck there is that it would have a railing. Right now, it's a cliff face, so it's really dangerous. We have 2 small children, and luckily nothing's ever happened, but it would give us a lot of peace of mind, especially when they have their friends over. That would be a really nice way to kind of keep that enclosed, and it wouldn't really be adding all that much, and there wouldn't be anything under it. It would just be posts.
No one uses the road now, the McGavick Pike portion?
That's correct.
Okay.
You said it was blocked off.
It's blocked off. It ends, I'm familiar. It's just sort of you're going to run into the river if you keep going. There's a sign that says don't go.
Yeah.
And I'm Yvonne Sims at 4127 Moss Rose, directly across the street from them. And I have been there for 17 years. And so I came here in support of, and can definitely, nobody goes down there with a car. Dead ends.
Great. Any questions?
I will say that the drawing helped understand what was going there a whole lot. Not telling you how your package was, but.
Yeah. Well, that was my contractor. I didn't do that. He had to go.
You might not be sitting here if that drawing had been part of your original package.
Wow. I'll have to let him know that.
All right. So did anybody have any other questions for the applicant? Or did you all have anything else to add? Okay. All right.
I make a motion.
We'll close the public hearing.
Yeah. Now I'll make a motion to
grant the variance?
Yeah, to grant the variance because it is an odd lot.
The river's there.
The river is there. I mean, safety issues, if you want to take it one more step, since you're going to have that.
Okay, I have a motion. Is there a second?
I'll second.
Motion, have a second. Any other discussion? All in favor, say aye.
Aye.
Any opposed? Motion passes. Good luck.
Thank you.
Moving on now to our short-term rental docket, starting first with case 2019-319 involving property at 3425 Town Village Road. Is the applicant here on case 319? So this is an item A appeal challenging the denial of a short-term rental permit for operating prior to obtaining the legally required permit. Mr. McBroom is here on behalf of staff, and he'll make the presentation. Is there anyone here in opposition to case 319? Seeing no opposition.
Are you opposed? You're the applicant.
He's the
Okay.
appellant. Seeing no opposition, the applicant will have 5 minutes to make the presentation after Mr. McBroom makes his.
All right, Mr. McBroom. Uh-oh.
Good afternoon, Board. The operation dates for this property were July of 2018 through May of 2019. There were 40 rentals. It had no permit. The host cease and desist letter was sent on October the 5th of 2018. There were 2 complaints. Based upon the wording of the complaints, they both seem to be for the same incident. And the description of, or the body of the complaint is here for you to read, but I will not go through that entire thing. But I will surmise by saying that it was a rather raucous party that was reported in the complaint. There was another action that was taken on this property on January 24th, 2019. A warrant was issued for operating without a permit, and the advertisement was removed on May the 30th of 2019. The warrant resulted in the case appearing in court on June the 12th of 2019. The case was adjudicated, and the ruling that was handed down was $50 fine, court costs, and a 3-year injunction against operating a short-term rental. It was subsequently appealed, and at that hearing, the same ruling was handed down.
Why are we here?
Because the appellant filed an application. I mean, truly, there's an injunction, as we've said before on cases like this. The injunction is for one. The court injunction is for one issue. The board has jurisdiction over the issue of whether or not we erred. If the board determines that we did err, the court injunction, that does not override the court injunction. If the board determines that we did not err and there's a waiting period, that would run concurrently with the court injunction.
Okay. All right, tell us your name and why you're here. Press the button, and you need to press the button.
Yeah.
Name and address and why you're here.
Yeah, my name is George Fanos. The address is 3425 Town Village Road. I'm here for just made application for just excuse for permit RMBB short return.
Okay. And you did, I mean, it has been determined by environmental court, and the testimony from our zoning staff is that you did rent without a permit. So is that correct?
Yes, sir.
And then the best that we can do for you today is to allow you to obtain a permit within a year or less, but the court has said you can't have a permit for 3 years, and so it really doesn't matter what we do today, you're still gonna have to wait 3 years to get a permit. We can't override the environmental court. So I just want to make sure you are clear on what we have the ability to do. Is there anything else that you'd like to add in terms of how you've rented the property with or without a permit? Okay. Okay. Are there any questions for the applicant? All right, then I will close the public hearing. And, you know, just for anybody watching and for your information, an item A appeal, by definition, is one that says that the zoning administrator and the code staff made a mistake. And in short-term rental cases, especially ones that are charged with operating prior, the zoning administrator almost never made a mistake because there's an advertisement out there and there's a review and there's history that you've rented. And in this case, there's testimony that you have given that said you rented without a permit. In those cases where there's not any other overriding information, we have the ability to give the applicant between a day and a year in which they have to wait to get a permit. And it's based on the circumstances of the property. In this case, the court has said that you have to wait 3 years from the time that you were in court, which I believe was testified sometime in June. And so even if we were to give you less than a year, you're still going to have to wait the amount for the time that the court has said. So we just don't really have any leeway in this. And so, you know, I think that, to me, the motion is that the zoning administrator did not err and that you would be eligible to apply for a permit, 1 year from the environmental court finding of June 12th, which means that you'd have the ability to get a permit 3 years after June 12th. Is that?
You could do that. You could make that motion. You could also make your standard motion of 1 year from the date of finding by this board. He can come in and apply, but he still would not obtain the permit because of the injunction. So
okay, well, that's fine. I'll say
kind of semantics at this point.
I'll say 1 year from the finding of this court. That'll be my motion.
Second.
A motion and a second. Any questions or comments? All in favor, say aye.
Aye.
Any opposed? That motion passes. Good luck.
Thank you.
Next case on the board's docket is case 2019-361. This is a case that was heard at the last the public hearing was at the last meeting. The case failed to receive 4 affirmative votes. The public hearing is closed. Ms. Santford, did you have an opportunity to watch the video of this hearing?
Yes, I did.
And are you prepared to vote?
Yes.
All right, so at this point, it would be appropriate for the board to make someone to
be heard on this, if I could.
The public hearing is closed, unfortunately, so we can't hear from the public.
I wasn't aware that it was even continued.
The public hearing occurred, it was noticed, it took place, it was advertised on YouTube, and it was closed, so the board can now take a vote.
And I guess the question was that and it's common for us to allow the council person to speak at will, but typically not after, sorry, you got to wait, not after the public hearing is closed, and so we did allow the council member to speak. So
typically the council members can speak regardless of whether or not the public hearing is closed, because the council members are always afforded the opportunity to speak, whether that's at the beginning of the meeting or during the hearing or after the hearing. So because the council member spoke, that did not reopen the public hearing. The board could vote to reopen the public hearing, but based on the last hearing, you heard the information from the appellant as well as the opposition. To the extent you're inclined to open the public hearing, I would recommend a deferral so that we can notify the opposition in case they want to come back.
Yeah, and I think that, well,
the appellant is here, but I mean,
The appellant is here, but the opposition is not because the public hearing was closed.
Well, and this is a case that we spent really a good bit of time on. At the last meeting, we heard both sides were represented by very competent attorneys who made compelling cases. And so, I really hate that you have been here all the time wanting to speak, but I think that
I was under the impression it had been reopened. When you allowed testimony from Mina Johnson, I thought it had been reopened.
Council members can speak whenever they would like to.
Our board rules allow, and Council Lady Johnson is still an active council member, and our board rules allow council members to speak pretty much at will at any time during the process. And that was what I wanted to clarify, just to make sure that her speaking didn't create any issue.
And I was just going to mention, for the purpose of the record, we do have your letter, and your letter has been made a part of the case file. So if you articulated everything you wanted to say today in that letter, it is a part of the official record.
And was part of the case file last.
Pretty much, that's what I wanted to do.
Okay.
And I wanted to make sure that you were aware that there is definitely opposition.
Yes, and
And I would
absolutely.
like it noted for the record that I made an appearance, but I wasn't allowed to testify.
So noted, absolutely.
Let me say this here. I understand that councilman can speak anytime they want, but we did let her, she got up here and spoke. Usually they speak at the time everybody else speaks, and I think that as a matter of fairness, we should let this gentleman speak for 5 minutes, and
That may depend on how.
But sir, let us talk
If we
about.
Can I
reopen
see
the public
clarification? Will we need to defer it
Yes.
and come back again?
Yes, if we reopen the public hearing, well, we will need to defer it so that the opposition who was here last time when the public hearing was closed has noticed that it's reopened in case if the public hearing's reopened, if they wanted to be here for that. This is an instance where the board the motion failed to receive 4 affirmative votes. It's only open for 30 more days, so if it is deferred, we've got room for one more meeting to the first meeting in October, but we would have to receive a vote by that date, or else it would.
Well, and I'm
be
personally,
denied.
I'm inclined to say that we should not let the gentleman speak. I have watched the case. You all spent a long time debating this case in my absence, but I reviewed it last night, and I feel, if anything, Councilmember Johnson spoke against the case. She didn't mean to, but in essence, she did. Her words were that the council's intent was that a natural person would be the owner of a short-term rental property. Unfortunately, a revocable trust is not a natural person. As one of the lawyers on the board, I will have to agree with the votes that came down before, and I will vote with that majority.
And I did not realize that allowing him to speak would require the public hearing to be open. So I don't think we should go there. I do think that in the future, I think we need to think about having Metro Councilman come in and speak after the fact, because it does put gentlemen like this in the position of hearing someone speak and then not getting a chance to. But his record is and I know personally that I looked at all the letters that were in the file. So
it is noted. The opposition letter is noted, and it is in the file, and it was part of the case record when we heard the case. And so, unless there's a motion that we do defer this and reopen the public hearing, is there a motion?
Could I
think this
strike
motion to
whatever?
complete-
I'd rather not have this reopened.
No, sir. It's not open at all. And so.
It's over.
Mr. Chairman, I think that we have our 4th vote.
That we do, and per our board rules, in this case, we take a new motion. And so I think that the motion was the motion was to deny the variance, or the motion was to support the zoning administrator. The zoning administrator did not err. And so someone.
So that was my motion last time, I think it was, wasn't it?
I believe it was. I don't have the.
I watched it last night, yes.
Did I articulate it better?
Yes.
Okay, thank you.
So someone, if.
I make that same motion I made last time, because I did it better last time.
and I'll second it.
Okay.
All right, so there's a motion and there's a second that to uphold the zoning administration, uphold the zoning administrator's cancellation of the SDR permit due to a change in ownership. And there's a second. Is there any discussion? All in favor, say aye. Raise your hand. Opposed? That passes 4-2. Next case.
The last case on the board's agenda for today is case 2019-402, involving property at 1525 12th Avenue North. Is the applicant here? We have an empty room, save the prior appellant. So I believe that this is, applicant is not here, so the board has a discretion to.
Have they been here before?
Not to my knowledge.
I'll move that we defer this one meeting. I have a motion, have a second. Any discussion? All in favor, say aye. Aye. That passes. And we're adjourned. Huh?
Adjourned. Quick.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.org.